Please, Lordship.
Yes.
Lordship, I beg to mention item number 1.
Yes.
I'm the amicus in this case.
Yes.
My lord, on 25/11/2025,
Yes.
the NHI's here were respondents 6 and 7 were directed to file an affidavit. Here,
Yeah.
the main respondents, this is Dimapur Kohima road construction.
Yeah.
The affidavit in compliance, it was filed until it was filed this morning only, and I received a copy just now.
Okay.
So, my lord, this I would like to assist the court, I would like to read it.
Yes.
So let it be next week. And the affidavit not being the report of the court also, because it was until it was filed just now. This morning.
Okay. Okay. Mr. Takamasa, learned senior counsel, assisted by learned amicus curiae. With concern from the other side, press for listing the matter next week. The next week, as he has received the affidavit filed by the respondent number
6 and 7.
6 and 7 today morning, and he needs some time to go through the same and to assist this court. The prayer having not been opposed by the state respondents and also by other respondents stands allowed. Rest is the matter in the next week. You give the names you are representing.
Final.
This is the cost.
May I please, Your Lordship?
Yes.
I beg to mention item number 2, Lordship.
Okay.
In the last occasion by order dated 4/12/2025, I was directed to file an affidavit, Lordship, with regard to the uploading of the beneficiaries in the Pushan Tracker app, Lordship. Lordship, I have received the instructions, so I may be granted a week time, Lordship, to file the affidavit.
You are for the respondent number 5.
Lordship, I am for respondent number 3, Lordships.
3.
Lordships, let the matter come up next week, Lordship.
Next week.
Lordships.
Miss, your good name, please.
Apila Sanktam.
Apila Sanctum, learned counsel for the respondent number 3. With concern from the other side, press for listing the matter after a week.
Lordship, next week, Lordship. In the meantime, I'll file my affidavit, Lordship, as directed.
So as to enable her to file the affidavit in opposition as directed by this court by order dated
4/12/2025.
4/12/2025. Any objection? The learned counsel for the petitioner submits that she has no objection. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that recusal lays the matter in the next week. In the meantime,
Oblige.
learned counsel for the respondent number 3 shall file the counter affidavit. Okay.
Oblige, lordships.
Your Lordships. Lordship, I'd like to mention item number 3, 4, and 5, Lordship. By order dated 4/12/2025, I've been directed to file the affidavit. Now, as far as 3 and 4 is concerned, it's with regard to implementation of the menstrual hygiene scheme, RTSK, in the state, Lordship. Now, we have obtained instruction from the district about the implementation, Lordship. I've received the instructions. The affidavit is under preparation, Lordship. So if 3 weeks may be granted, because I have sent for vetting again, Lordship. Because this is with regard to, I have to place on record the factual figure as to the implementation of the scheme, Lordship. So I've taken the consent of the counsel for the petitioner. So in item 3 and 4, if I may be given 3 weeks time, Lordship.
Okay, Mr. Mozoy, learned counsel for the respondent number
4.
Respondent number 4 with consent from the other side, press for listing the matter after 3 weeks.
3 weeks, Lordship.
So as to enable him to file counter affidavit,
Additional affidavit,
additional affidavit,
as per the query put up by the court.
as ordered by this court by order dated 4/12/2025.
Yes,
2025. Fair allowed.
Lordship, in similar, in item number 5 also, here in regards to blood bank.
Yes.
So even here also, we have made a mention in the last occasion, because of the scarcity of specialized doctors, because blood bank has to be manned by specialized doctors
Yes.
and technicians, Lordship. Now, or by order dated 4/12/2025, I've been directed to show the roadmap, how to go ahead with getting more specialized people, Lordship. And as your Lordship is aware, now for the PG course, it's through the net. On your own, you cannot apply for any specialized post, Lordship, for course. So on this regard also, Lordship, 3 weeks very time will be given, Lordship. We are preparing the affidavit, Lordship.
Okay.
I've taken the consent.
Mr. Mozoy, learned counsel for the respondent number
Respondent number 5,
respondent
5 and 6.
5 and 6
Yes.
with consent from the other side, press for listing the matter
2 and 4. 2 and 4.
after
3 weeks.
after 3 weeks. So as to enable him to file additional affidavit or counter affidavit.
Additional affidavit.
Additional affidavit as directed by this court by order dated 4/12/2025.
Yes.
Fair allowed.
I'm deeply open.
Maybe sorry, I'd like to mention item number 7.
7.
This is
Okay.
for the union of membership. I think that this may be listed after 3 weeks.
After
3 weeks.
3 weeks. Okay. Mr. Yangarati, learned CGSC
This
with consent from the other side.
Mr. Zimami.
Mr. Azimami,
Yes.
learned amicus curiae.
No, my lord.
No, your petitioner. Learned counsel for the petitioner. Press for listing the matter after
After 3 weeks, Lord.
after 3 weeks. After 3 weeks. Fair allowed.
What about?
Mr. Seki, you are here. That's respondent number?
Respondent number 8.
Respondent number 8.
Hello.
So the other respondents also can give the name to record their presence. Record the presence.
Oh. Right.
My please, your lordships, beg to mention item 49 on behalf of the CJSC. I've taken the concern of the opposite party if this matter can be listed on 11th of March.
Here you are for the petitioner.
Yes, whatever.
14.
Whatever.
Ms. So learned counsel for the petitioner with consent from the other side. Price for listing the matter after
March 11, if we can.
on
fix
March
it.
11. Is it March 11? Okay, March 11. Fair.
Lordship, similar prayer for 50 as well, item 50.
Okay, same order.
Right.
Much obliged.
I beg to mention hearing item number 1441.
40.
1441. My seniors in this post say this matter be fixed after 3 weeks. 1441.
Mr. Your name, please.
Oluto Shepri.
Learned counsel appearing on behalf of Mr. Who is the conducting counsel?
VTO.
PTO, learned conducting counsel for the appellant.
Yes, sir.
With consent from the other side, press for listing the matter after 3 weeks. As a leading counsel, Mr. B. Theo is indisposed of. Bear alert. You are for respondent number?
So for the state respondent, madam.
All the respondents. Okay. Obliged respondent.
Ladies, Your Lordships, I beg the motion for the number 39. As the counsel for the appellant is indisposed, I beg the matter will be taken up after the appeals.
Miss, your name please?
Mr. Jeffrey Lordship.
Learned counsel appearing on behalf of Longkumar. Learned conducting counsel for the appellant. With consent from the other side, press for listing the matter after 3 weeks. Okay, bear allowed.
Ladies, Your Lordships, I beg to mention hearing item number 42.
Yes,
My senior is in trust. I pray that this matter may be fixed on 11th February.
11 February. Miss, your name please?
Lordships, I appear on behalf of the appellants, Your Lordship, in the same matter, item number 42.
Your good name please?
T. Kashyap, Your Lordship.
P. Kashyap. Learned counsel for the petition.
The department.
Mr. Mozoy for respondent number 2 and 3. And you are for, madam, you are for?
I'm for the private respondent number 4 to 11.
Private respondent number 4 to 11. Miss so and so, learned counsel appearing on behalf of Mr.
R. Iralo.
R. Iralo, learned conducting counsel for the respondent number 4 and 11. Price for listing the matter after
On 11th February.
on 11th of February. Any objection?
Lordship, if I may the matter be fixed on the 18th of February, Lordship, if Your Lordship would be
18th
so
of
pleased.
February.
Yes.
Which is a
Okay.
Wednesday, Lordship.
Okay.
Much
18th
obliged, Your
of
Lordship.
February. Fair allowed. Okay.
Much obliged.
Obliged.
Please, Your Lordships, I beg to mention item 9 from the admission list, Your Lordship. This matter may be listed after 2 weeks, Your Lordship. I am mentioning on behalf of additional AG B. Shukri. Item 9.
Miss Ina Hole. But this is
Matter will be listed next week, Wednesday, Lordship.
next week.
Early disposal is required in this.
Miss Ina Hole, learned counsel appearing on behalf of Miss B. Shukeri, learned additional AG. With consent from the other side. Any objection, Mr. Zamir?
Chief, let it be after 3 weeks because coming 2 weeks I'm likely to go.
There is urgency. The abilities are in the interim order, stay order, Lordship.
Yeah.
And Lordship, we can kindly consider one aspect of the matter, Lordship. The appellant who is holding the principle.
No, you say we are ready to hear the matter. If you are not ready, then what to do?
Next week, Lordship.
Next week, if he is not available, then what purpose will be served?
And that may be fixed, Lordship, after 2 weeks.
After 2 weeks.
And that may be fixed, Lordship.
Mr.
No further
Zamir?
adjournment.
2 weeks, that's all.
Okay. Press for listing the matter after 2 weeks. Pair allowed. Press is list the matter after 2 weeks.
Lordship, on 11th, 11/2. 11/20 local. Senior.
11. Okay. 11. Yeah, there is interim order.
Yes, that may be continued.
Okay. Interim order passed earlier shall continue.
Lordship, it was made absolute under first day itself. Interim order.
It will continue till final hearing.
Yes, Lordship.
Yeah.
Your Lordship, I beg to mention item 6. Let the matter be fixed after 1 week.
After 1 week. Any objection?
We have to file an affidavit, Lordship. They haven't done that yet.
We have been informed that like the document that was sent there was legible, so.
Okay. Miss, your name please?
Maung Kala.
Learned counsel appearing for the respondent number?
10.
Respondent number 10. Press for listing the matter after
1 week.
1 week, so as to enable her to file affidavit in opposition or additional affidavit. Additional affidavit. Pair allowed.
Your Lordship, I beg to mention item 10. Kindly list the matter after 3 weeks. 10.
You are for petitioner.
Yes.
Ms. So learned counsel for the appellant. Press for listing the matter after 3 weeks. After 3 weeks. Pair allowed.
I beg to mention item 43 to 46.
Forty-three to 48.
Yes.
So learned counsel for the appellant. Any objection?
No
With
objection.
consent from the other side, press for listing the matter after 3
2
weeks.
weeks.
2 weeks.
3 weeks.
3 weeks. Pair allowed. Okay. Is there any interim order?
No. My pleasure, Lordship. Lordship, I beg to mention item number 18 and 19. On behalf of the defense. Lordship, we kindly list this matter after 1 week.
Miss, your name please?
Pichano,
Learned. PP.
18 and 19.
You are for PP.
Lordship, on behalf of the defense.
On behalf of Livisa, learned PP.
Maybe on 4th February.
4th of February. With consent from the other side, press for listing the matter on 4th of February. Pair allowed.
Lordship, item number 35 and 36. On behalf of the people. Many this is matter after 1 week. 35 and 36.
On behalf of
Busy movie.
is so and so learned government advocate. Other for Mr. B. Zimomi,
Lordship,
learned government advocate.
Lordship.
With consent from the other side, press for listing the matter after
1 week, Lordship.
1 week. Pair allowed. Who is for the appellant? No.
Yes.
You inform the appellant?
I'm for state, Lordship.
No, you are mentioning the matter, but did you inform the other side?
No, Lordship.
Okay. None appears for the appellant. On call. Okay.
Lordship, item number 38 has well on behalf of Busy.
So and so learned counsel appearing on behalf of E. Zimomi, learned government advocate.
Lordship,
With consent from the other side. Any objection?
No, Vishnu.
Consent from the other side. Press for listing the matter after 1 week.
2 weeks, Lordship.
After 2 weeks. Pair allowed. Yes.
Lordship, item number 51 on behalf of Abituli. Depending this better after 3 weeks.
The appellant was.
Okay. Heard Mr. Mauzame, learned counsel for the appellant. And also heard Miss
Pichano on behalf of
Ishano, learned counsel appearing on behalf of Mr.
this is Abituli.
Mrs. Abitari. Learned government advocate.
Lordship,
See, press for listing the matter after
3 weeks.
after 3 weeks. The pair having not been opposed by Mr. Zomin, learned counsel for the appellant, stands allowed, recess and list the matter after 3 weeks.
Thank you, Judge.
For admission, item number 8.
May I please, Your Lordship? I am appearing on behalf of respondent number 5, Lordship.
Yes. You are Mr. Das
Kakuti.
Kakoti. A Kakoti.
Kakuti.
Respondent number 5. Yes. Who is for the petitioner?
No research. No, Lordship, in fact, this matter relates to non-payment of the claims of the hospital because the scheme is under the insurance mode. Now, out of the total of 180 CR claim that has been placed, we have been informed that there are around 20 CR still pending. Now, Lordship, I have already placed on record the letter written by the respondent number by the Allied Health and Society, Lordship, the respondent number 4, whereby we have informed the insurance company, there's respondent number 5. In view of the meeting held at Delhi with the National Health Authority, because there was a clear direction under the minutes, Lordship. It's already in the affidavit also. That they should clear all the claims. And in case of any detection of fraud, the state will recover the money and it will be paid back to the insurance company. Now, as per the latest figure that has been given, Lordship, as per our data record, Lordship, they have rejected 2,613 claims. Outrightly rejected, Lordship.
No, where is that minute submitting?
Lordship will find the affidavit filed by the respondent number 5 on 1st 2025, 1st December 2025. Lordship has found. If I can assist the court.
First of December.
Yeah, 1st of December 2025. They filed the affidavit on 1st December 2025. Huh?
Yes.
Now, Lordship, may kindly come to the next page 6 of the affidavit. Minutes of the meeting date 28/9/2025. Lordship has found. Lordship, may kindly come to the bullet 1, key discussion point. 1. It was recalled that in a meeting held on 2nd May 2025, FGI has committed to settle all claims. Lordship, this is very important. FGI has committed to settle all claims of hospital outside Nagaland and within Nagaland, non-fraud cases by 15 May 2025 and alleged fraud case by 30 May 2025. So the deadline given to them by the National Health Authority was on 30 May 2025. Now the action of the respondent number 5, Lordship. Outrightly rejecting claims. In spite of the commitment given by them, that they will clear it by 30 May. Now, this is the way, this is the manner the FGI is functioning, the respondent number 5. Lordship, a commitment has been given by the government of Nagaland that in case of any fraud that is detected, which is proved, the government will take every possible means as per the policy, Lordship, to recover the fraud amount and pay back to the respondent number 5, that is the insurance company. And they themselves, they have annexed this minute solution. Now, as for our data, Lordship, I may be allowed to share this data also. This is from the portal. Lordship, we can come to the first page. The amounts, Lordship, might not be relevant for us, but Lordship, we can come to the last portion, the 2 columns, Lordship. ABPM JOY, this Ayushman Bharat, rejected in the month of December. Claim insurance rejected by FGI, that is Future Generic Insurance. Number is 2,613. Going by the minutes, the commitment, they said like any fraud case or so, they'll clear it, and any recovery to be made, will do the recovery. And this is not the commitment given by us, but by themselves, the future generali insurance, the respondent number 5. Now, Lordship, after detection of this rejection, unfortunately, we could not communicate to the FGI because the CEO, the Chief Executive Officer, is on leave. So we'll be communicating to them very soon, by next week, Lordship. On what basis these claims have been rejected for? Now, Lordship, there have been instances where they have already cleared the claims. Later they're saying it's a fraud. Is it possible, Lordship? They should have some fraud detection mechanism in the system, because that is a part of the MOU. They should have fraud detection mechanism within themselves. They should detect it, and they should flag it that there is a fraud case. So further investigation has to be done by both parties. They have not done it. They have paid the claims. Later they're saying this is a fraud case.
No, now we are not concerned with that.
Yes. Now coming to the meeting minutes, which was signed on 28th of September 2025. They have reiterated the earlier commitment that they will clear by 30 May. Still, they are rejecting the claims.
Okay. Yes, Mr. Kakote.
Lordship, we are basically following the NHA portal, that is National Health Authority portal. As on date, Lordship, what I have been instructed that we have attended to each and every claim that has been, or every case that has been floated in the website. And as on date, Lordship, no open or unattended case remains to be actioned by the Generally Central Insurance, Lordship. And further, Lordship, my friend on the last occasion has furnished this particular document. And if you kindly turn over to the next page, Lordship,
yes,
the total amount is showing 7 crores 22 lakhs something, Lordship. So my instruction is ki we are, since the portal is not clear regarding this pendency, as we have attended each and every case. So let them furnish some clarification with respect to this particular thing. Lordship, we have almost paid more than 140 crores. So this is just, Lordship, 7 crores. So if any clarification is required, let them provide the clarification. If at all we need to pay, we'll pay and close, Lordship. But firstly, let them give us the clarification with respect to this pending, because the website, the portal shows nothing, Lordship. No unattended case or open case left to us. So that is the main difficulty, Lordship.
Then what about their commitment, Lordship? Their commitment on
We have paid more than 140 crores, Lordship. And as per my friends, only this particular document, only 7 crores is left. So if any clarification is required, let them clarify. Then accordingly, if it all needs to be paid, we will pay, Lordship.
Our state portal and the NHA portal, National Health Authority portal and the State Health Authority portal is linked. It's linked, Lordship. So whatever is appearing in the NHA portal will appear in the state portals.
Lordship, what my humble submission is, give us some breathing space and let both the parties sit together, have some meeting and sort it out.
If my lords may kindly appreciate, I'm for the respondent number 6, the Private Hospitals Association, the Doctors Association. Only one member that is not part of us is the CHISR Hospital, Dimapur. The rest are all before the Zombie Court, represented by the respondent number 6 association. The entire bill that is said to be cleared, we are asking the information from all the private hospitals, individual hospitals. And I do not know whether the amount is actually 7 crores or 20 crores, because we are also in the process of collecting the information. But the amounts are yet to be cleared, Your Lordship. That is also the reason why this matter cannot be closed.
No. Who prayed for closing the matter?
Your Lordship, the FGI, the respondent number 5, on the earlier occasion also they wanted this matter to be closed.
No.
In fact, Lordship, it has been placed on record. Now, what is happening is the future generic insurance, that is the respondent number 5, is trying to negotiate with the hospital, which is not in terms of the policy. We are the authority who pays the premium to the insurance company. So any negotiation should be through us. Behind our back, they are negotiating with the hospital. And this court has already given a clear direction that there should be no negotiation.
Lordship, I beg to vary with respect to that submission, Lordship. If that is being so, let him file some clear-cut affidavit.
No, that is in place on record, this last.
Because, Lordship, we have procured no use certificate from most of the hospitals, Lordship. Many hospitals we have procured, Lordship. And in this affidavit only, we have annexed no use certificate from 15 hospitals. And even if they say that something is still remaining from that hospital, Lordship, so there is some confusion. Because the portal, we follow the portal, Lordship. So portal shows, and our edition, this affidavit in compliance that is filed on 1st December, Lordship, that we have mentioned specifically, Lordship. In that, Lordship, it may take this affidavit in compliance that we have filed, Lordship. We have specifically mentioned, Lordship, that already we are having para 9, Lordship, para 9. Further, it is pertinent to mention that the said set of claims includes several claims pertaining to 15 hospitals, from which this answering respondent number 5 has already procured and holds valid no due certificate. So even after holding no due certificate, the portal shows something is left with this hospital.
No, Your Lordship, in that affidavit, which we have already discussed earlier, only 2 NOCs were present, whereas the number claimed is 15, Your Lordship. So that affidavit itself was also misleading. But at this point, if they claim that they have received NOC, we have also made it very clear before this Honorable Court that if any negotiation is to take place, it has to be through the state authority. And the association is also clear on that. So if there be any settlement, Your Lordship, the same will be placed before this Honorable Court through the state authority.
In fact, we have written a letter to all the hospitals within that state, those who are internal hospitals under the scheme. We are yet to get the response from the hospital concerned. Only after getting those detailed information, we can place on record. Whilst the statement made in paragraph 9 is concerned, they are saying 15. But that is their claim. But our report should speak about it because we are the implementing agency. They are doing behind our back. Lordship, in this regard, Lordship, if 2 weeks may be granted, we'll place on record all the material portion. Because, like my learned friend has already pointed out, the paragraph 9 of the affidavit is misleading, Lordship. And they should be careful that this affidavit is on board. And we have records with us, Lordship. They're compiling, the private hospitals are compiling.
But Mr. Muzoi,
Lordship,
if the portal, state portal and the portal of NSA is interconnected,
yes,
then whether the submission you have advanced before this court today,
Lordship,
the data,
the claims should take
claims,
yes,
that has remained to be paid,
yes,
is reflected in the portal.
In the portal itself, because this is an extract from the portal. The document
This is
that
from the portal.
Yes, from the portal.
Then, Mr. Kakote, why this amount is not, you are submitting that it is not available in the portal?
Lordship, correct, Lordship. Because, Lordship, as per my instruction received, Lordship, there is no open or unattended case remained for action by the insurance company, Lordship. So, if any at all is, it is not reflected in the web. That's why I propose, Lordship, let the parties have a meeting together, twice or thrice. So then these issues, small issues can be sorted out, Lordship.
No, Mr. Kakote, you see this as submitted by Mr. Muzoi.
Correct, Lordship.
These data are collected from the portal of NHA.
NHA.
So as per this data, 2,613 claims have been rejected.
Rejected. So that's why, Lordship, I propose to let them have a meeting together and sort it out. What is the difficulty in the
Because firstly, they
some
have
amount is remaining to be paid.
record that this portal that the data we have shown is completely with the NHA. Let them come with the step. Then the question of negotiation comes up. The meeting, meeting with the cashier. Because Lordship, we have numerous meetings with them. And in every meeting, they give commitment, we'll clear it. We'll clear the claims. But once they go back home, they turn it down. Then they start rejecting. Lordship, the letters I've shown, Lordship, on 25th of September 2025. A commitment has been given. Now, recently they have rejected more than 2,613 claims. They say they give some commitment in the meeting, they say something in the court, and then when they go back, they do something different. Lordship,
okay.
Our concern is for the beneficiaries, Lordship.
Yes.
The citizens are suffering. Now the hospitals are refusing to give treatment. Now who is going to be affected by the action of the NHS? The general public.
Okay. We will go through the minutes of the meeting and the data you have produced before the court today. And also the affidavit filed by the respondent number 5. And we will pass necessary direction and orders. We have not gone through the minutes of the meeting, actually. We'll pass necessary order.
Lordship, any date may be fixed because I have to come down to Kohima. Today only is an exception, Lordship. I
always come on time, Lordship.
Any date, Lordship, may be fixed. Any date.
Yes, suggest the date.
2 weeks, Lordship.
After 2 weeks.
Yeah, after 2 weeks.
Lordship, or after 3 weeks, in date may be fixed.
After 3 weeks.
Lordship, we are talking about the financial year 24-25. We are in 26, Lordship.
Can it be on 11th of February?
Lordship, can it be on 18th?
18th.
Next day? Because PIL matters are fixed on Wednesday only, 18th.
Normally we have division bench on Wednesday, so even if it is said after 3 weeks, it will come on Wednesday only, Your Lordship.
Yes. 18th?
18th.
18th.
Obliged, Lordship. Orders.
Grateful, Lordships.
Grateful, Lord.
For orders, item number 11.
This in December.
Lordship, I have already served on this point by the respondent number 5 by way of domestic service. And today, the fact I've also filed my affidavit on 15/12/2025. Lordship, now the considering service is completed. If this matter may be listed for hearing.
Heard, Mr.
James Nimai.
Learned counsel for the appellant and Ms. Inahole
Yes, sir.
for the state respondents.
1 to 4.
Respondent 1 to 4. The learned counsel for the appellant submits that service upon respondent number 5 is effected by the synod and an affidavit is also filed to that effect. It appears that notice upon respondent number 5 deemed to have been served. But but the respondent number 5 remain unrepresented today. The learned counsel for the appellant submits that the matter may be listed for hearing. Accordingly, taking note of the submission of learned counsel for both the parties, it is provided that recess and list the matter for hearing after
In the course of the
in the course of the
For orders, item number 12.
Please, Your Lordships. Lordships, item 12, 13, 14, 15, 16, and 17 are analogous matters. Lordship, perhaps if I start, we will not be able to finish today. Can it be fixed on the 18th of February?
18. Okay. The learned counsel for the appellant. With concern from the other side. Any objection, Mr. Angam? No. Press for listing the matter on 18th. 18th of February. We are allowed.
Can they be listed as analogous?
All the
11
matters?
11 to 17.
Yes.
Very good. Much better.
For orders, item number 20.
Please, my lordships. Lordship, regarding that item 35 and 36 that was mentioned in the morning, they did not take my consent. Otherwise, I filed this IA to delete 2 names. Only 35 and 36. Inadvertently, we implemented 2 names as respondents. In the latest extension order of the contract assistant professor, 1 name is already out.
But this matter has already been mentioned.
Yes,
Number
Lordship.
20.
Just the respondent advocate is also there. She informed me. Opposite party.
Yes,
government.
we have already given the date, perhaps.
That is previously fixed on 11/12/2026 to list the matter. However, in the meantime, the emergency arises that I want to delete 2 respondents' name.
No, where is your IA now?
IA is there, Lordship.
IA?
IA number 9.
Item number?
35.
35.
IA is there.
Then who had mentioned the matter?
Government advocate.
May I please, my lord? Lordship, I think it was Ms. Bichano on behalf of VC Mo.
Yeah,
Lordship, I think, yes.
Just for deletion of 2 names, that is.
Lordship, since the counsel who is taking up the matter on behalf of the state respondent is not available today, Lordship, if the matter can be listed next Wednesday, my lord.
Yes, can be.
After deletion of this, again, that newspaper publication is going to be filed. We have already filed, but they say that after deletion of these 2 names, they have to correct the cause title, and then we are allowed to file. Otherwise, we have filed it.
No, now without hearing the other side, we will not pass any order.
Correct. If it can be listed next week, my lord.
Next
On
week,
next
yes,
Wednesday.
Next week.
I'll give you a pledge.
Item number 20, Lordship, this is for those who are appearing.
Lordship, may kindly see the order dated 21/1/2026. The last 2 paragraphs. Both the orders appears not to have been complied with, Lordship.
Order dated?
21/1/2026.
Yes.
Last 2 paragraphs. Some directions have been issued by this honorable court. It appears my learned friend has not complied with put. That ground itself should be a ground for dismissal of that bill. You see the order?
You have not furnished extra requisite copy to him.
To them, Lordship. Lordship, I beg your pardon, Lordship. I thought that today they were supposed to give me the list. They did not give me the list. Before this honorable court, the
What list? We have
the name of
furnished
the
before the honorable court that for which respondent we are appearing, we have furnished a list. Even today also, I am ready with the list.
I was also supposed to be furnished before this honorable court. I prayed for that. Anyway, we can furnish it, but with respect to other respondents, Lordship.
5, 7 and 11. 5, 7 and 11. You have not taken step.
Lordships, in the order passed by this honorable court, for whom we have instructions to appear, are also reflected. So it is known to them. Second part is, they were directed to take steps by registered post. It appears that no steps have also been taken. Now, it appears my learned friend is trying to go for paper publication. That may not be possible at this stage because first, they have to comply with the order passed by this honorable court.
Lordship, within my limited understanding, it was supposed to be listed today so that those councils who wants, like in the previous two writ petitions, those who want to receive the service notice, they can be excused. However, those who do not come forward, I am supposed to pray before this honorable court for paper publication. That was the last.
No. Madam, the problem is that for paper publication, first you have to exhaust the other procedure.
Correct, Lordship.
Yes, Lordship, under section CPC 520, Lordship, I do. But in some circumstances, Lordship, where it is impracticable, Lordship, this is the discretion of the court, and in so many cases where there are so many respondents, normally paper publication are provided. Just in the recent writ appeal before the Honorable Division Bench at Gauhati Principal Bench also, we received paper publication, and only from there we went up to Gauhati to file our wakalatnama. That is how then, if the appeal happens to be there are some impossibility when there are lots of respondents. That is my humble prayer before this honorable court, and on that other day also I prayed before this honorable court on that.
In that
And
case,
that is the discretion of this honorable court, Lordship.
I do not
I'm not
argue with the discretion of this honorable court. The submission which my learned friend is making, when there are so many respondents, such as steps may be taken, but first thing first, they have to comply with the order passed by this honorable court and the mandatory requirements of the provisions of law. That is one. In this particular case, coming to our case, majority of the respondents, almost 80%, they are appearing before this honorable court. They are represented by the councils. So very few private respondents are left where my learned friend is required to take steps. What prevented them to take steps by registered post? Such an easy order which has been passed by this honorable court. My learned friend, she is not willing to act on the order passed by this honorable court, rather insisting for paper publication. We should go by law.
I beg your pardon, Lordship. It is advertently, I thought that today it will be listed, giving them one week to be listed today, and then that will be finalized. That was what my inadvertently, Lordship. So otherwise, it is not a deliberately.
No,
I will.
right. Now you take a step. We will list the matter after 4 weeks. You take step upon these respondents 5, 7, and 11 in item number 20.
5, 7 steps.
Very few respondents are left.
Yes.
who are not represented by the council.
Yes, yes.
So what is the difficulty?
No, I will, those. Sir, which repetition? There are all the analogous matters, Lordship. There are so many repetition, and this may be analogous, tagged as analogous matter. So, because of from the
I am appearing in item 20, 21, 22, 23, 25, 27, 28, and 29. About 40 respondents I am representing.
Yes, this
And
is
others,
the this is the
I
list.
have already furnished. So very few respondents are left. And that is also reflected in the order passed by this honorable court on the last occasion. My learned friend should go through the order passed by this honorable court
Lordship.
and take necessary steps.
Lordship, if I'm not wrong, Lordship, in writ petition number 51, they showed before this honorable court they are taking step for they are accepting notice for some of the respondents. In writ petition
Not served a copy.
51.
Which
Yes,
was
I have
to be
done,
served
Lordship.
in the course of the day. 1 week has already passed. They have not served a copy.
So after 4 weeks, then
This
in the meantime, you take a step.
Step through the councils.
Yeah. No. What if not through the council, but by speed post and also by usual process. Speed post and also by usual process.
Lordship, I humbly bring before the honorable court in all these cases that has been coming on. It is this honorable court was compassionate enough to give us paper publication, and as I have said, there are so many respondents, Lordship.
No, maybe, but can we directly go for paper publication without exhausting the other procedures?
There is a
You show
discretion
me.
of this honorable
No,
court,
no,
Lordship. Of course, this section CPC section 520. Of course, it is dear Lordship. But as I have read before this honorable court for honorable discretion, for those who are not present before this honorable court, the councils allow the petitioners to publish in the newspaper. Even in previous two writ petitions, similarly analogous matter, Lordship, paper publication was provided. I humbly pray for that, Lordship. Those who are not present before this honorable court, the councils, I will take care of that, Lordship. Those who are present before this honorable court.
Okay, we'll go through the orders passed in those two appeal. Thereafter, we'll take a call upon these matters.
Lordship.
Okay. After 4 weeks, then? After 4 weeks, we'll pass necessary order.
That is writ appeal 44 and all of them. 44 and 45.
Okay. But you furnish copy of the memo?
Yes, Lordship. I shall do.
Today
By today itself,
Okay.
Lordship.
Okay, next item.
For orders, item number 31.
I beg your pardon, Lordship. In writ petition 52, writ appeal 52, the name of the respondent number 9, she has already resigned from the post.
You file an interlocutory application?
Lordship.
We'll see.
Lordship.
For orders, item number 31.
So you have not taken any step upon respondent opposite party number 3, 5,
Your Honor,
and 6. Yes.
10 and 6? Sorry.
No,
Your Honor.
no, 3, 5, and 6.
Yes, Your Honor, we've submitted to the state and the respondent number 1, the hospital, in person on that very day. And the other 3 respondents we submitted via the speed post. For the union, AIMS, and the Nagaland Medical Council, we submitted via speed post. And
You have not taken a step through the registry of this court
Your Honor, we sent it via speed post registered.
directly, not through the registry of this court.
No, not through the registry. The order said that we can send either through the registry or through speed post, so we sent it through speed post.
No, we should not do the rest of it by speed post. I view the process, the rest of it with the registry.
No, madam, it ought to have been through the registry of this court.
Then I will post it again through the registry.
Yes, anybody appearing for the opposite party? Respondent opposite party?
Yes, my lordship. I am Samuel Abraham, appearing from Chennai. For R1, my lordship.
You are for?
I'm assisting my senior colleague.
Okay. For respondent number?
1.
1.
Your lordship, we will be filing our Wakalatama in the course of the day.
Okay. Heart.
Your Honor,
Yes.
if I may,
Yes.
the continuation of the treatment of the child.
Okay. Heart. Miss Barbara Nunes, learned applicant, stroke appellant in person, and also heart. Mr.
Samuel Abraham.
Samuel Abraham on VC, myself just a grouper in person.
Okay. For the respondent number 1.
1.
Respondent number 1. Office note dated 27/1/2026 indicates that the applicant appellant has not taken step for service of notice upon respondent number 3, 5, and 6. However, Ms. Barbara Nunes, the learned the applicant stroke appellant in person submits that she has taken step by speed post, not through the registry of this court, but directly. However, she submits that she will take fresh step upon the respondent number 3, 5, and 6 by speed post again. According speed post again. The learned counsel for the respondent number 1 submits that he will be filing the power during the course of the day.
Yes.
During the course of the day. Then you want to file affidavit here, objection here?
Yes, Your Honor.
The learned counsel for the respondent number 1 submits that he may be granted some time to file objection in this application. Pair allowed. Recessal list the matter. After 2 weeks.
Fine.
After 2 weeks.
Your Honor.
3 weeks.
The continuation of treatment.
Yes.
Thank you, Your Honor.
3 weeks.
2 weeks. Yes, that's fine.
Till then, interim order passed by the order dated. The interim order passed on 21/1/2026 shall continue. List after 3 weeks.
Thank you, Your Honor.
For orders, item number 32.
I-7 is for calculation of delay. It's a delay of 246 delay days. My understanding is appearing for the other party.
Yes, you have filed objection here. So what is the ground for delay?
I have stated in my affidavit, Lordship.
Paragraph number?
Concerning paragraph 3, Lordship. Paragraph 3. That the humble petitioner, that the humble in as petitioner has filed petition appeal the person so before the court. Mention 2. That the above mentioned petition has been disposed of by the Supreme Court by the The 3, Lordship. The petitioner was diagnosed as immune. Paragraph 9, Lordship. That's A6. Yeah, the Honorable Court heard that the respondent apparent to convey a fresh court of inquiry, giving the opportunity to the petitioners respondent to participate in the said inquiry after giving an opportunity of opinion. That the plaintiff they just made an order that falls 5/2005 only also, and immediately after the matter was forwarded to the head office for necessary action. That on the instruction of the head office, the instant matter has been filed, and on the process there is a delay of 246 days in referring the appeal. Look, the file went from table to table, Lordship. There was a delay of almost 246 days in filing this application.
No, table to table delay, is it the ground for condonation?
As a public office, Lordship, the decision is not taken by one officer.
No, maybe we have to treat the respondent in governments and also the other side.
Because of delay in progressing with the file from one table to another, Lordship, there was a delay of 246 days only, Lordship.
Two paragraphs, two short paragraphs to explain so many days.
I've seen.
And in the meantime, there was this vacation also.
This is
Well, Lordship, in the meantime, there was this winter vacation also. So there is a delay of it was about 30 days.
No, even if we not count the vacation period, then also there is delay.
Yes, Lordship.
Where is the explanation?
Yes, Lordship. Mostly because Lordship, the file moved from one office to another, one table to another, there was a delay.
No, that is not the ground.
Because
That
Lordship
is
is a
not
public office, so the decision cannot be taken up by one person only. But this file has to move from one table to another.
That is not the ground. Yes, what is your objection?
As your lordship has pointed out, there is not even a single D explanation. There is no cause shown, not even for a single D. Forget about how many days the admitted file is 246. That is their admitted file. But there is not even a single day explanation.
Mm.
It's just a blank statement.
Mm.
This should be dismissed. That is what I filed my affidavit. I started from para 3. That is para 11 of the condemnation application. Admitted fact, there is a delay of such and such. That is their own admission, which I am not calculating. 4, that with regard to 12 of the condemnation application, or 1 states that except a plan statement that the writ appeal could not be filed within the prescribed period of limitation. There is no explanation whatsoever about the delay as such. Continuation application should liable to be dismissed. In against para 13 and 14, R1 states that the petitioners did not disclose a state any ground to condone the delay. Includes approach, it's a single judge decision, but it is very clear. It cannot be.
No, now we are not on the merit of the decision.
No.
But we are on the condemnation of delay.
My lord, that is
And
why.
apparently there appears to be no explanation.
That is my submission, my support.
Lordship made my para 3, 13, Lordship. Great sense. That is a fit case for condone of the delay and the disposal of the writ appeal on merit of the ground set forth in the petition involves substantial question of law. The disposal of the writ appeal on merit should not cause any prejudice to the respondent. In the contrary, dismissal of the writ appeal on technical ground or without division shall prejudice the applicant petitioner and will result.
No. Whether there is merit in the appeal or not, that will be decided later on. First, we have to see whether delay is explained properly or not. If not properly explained, we will dismiss it.
The problem is, Lordship, file move from one table to another.
No. That is not
because
the
of
case.
the.
See, your prayer is from one table to another.
Yes, my lord.
Okay, so on which date, to whose table, then how did it go to whose table? At least that explanation that you should give. Simply a blank statement from one table to another is not enough. You have to show that you were sincere.
In the case, Lordship, I may be allowed to withdraw this without this IA and to other place.
No. That cannot be. Because it will cause prejudice to the other side. Because already right has been created in their favor.
There is no stay. Now there is no stay of the order passed by the single judge. So I'm given an opportunity to withdraw this.
No.
I will explain what is day-to-day delay, how it was there, the delay was caused.
You must have read the application earlier. When he filed it.
I pray is only for
You must have read.
withdrawal, Lordship. I'm not praying for merit application, Lordship.
No, you see, you have filed the interlocutory application, he has filed the objection. Now, if we allow you to withdraw the application and to file a fresh one, it will cause prejudice to the other side.
Lordship, there is no stay in the order passed by the single bench, Lordship.
Maybe.
If there is stay, then it is otherwise.
No.
There is no stay as such. So I pray that Lordship, my IA may be withdrawn.
We are dismissing your IA for condonation of delay. We will not condone it. We will pass the necessary order. Next item.
Much of that.
For orders, item number 33.
May I please, Your Lordship. Lordship, this I is for condemnation of the law of 26 days.
20?
26 days. Notice can be issued, Your Lordship, since this is for the first time, actually. The delay is explained from paragraph 5 to 9, Your Lordship.
What is the ground?
Lordship, the petitioner received the CTC of the order, Your Lordship, on 6/1/26, Your Lordship. Thereafter, he started collecting all the pleadings from his counsel from Delhi, Your Lordship.
Oh, when did you receive it?
6/1/26, the CTC, Your Lordship, through speed post. I received on 6/1/26.
Yes.
Thereafter, he started collecting all the pleadings from the his counsel from Delhi, Your Lordship. Lordship, in Kohima bench, there was a vacation from 13/12 to 13/1/2026. So if we deduct that amounts to 32 days. So if we deduct that 32 days, then there's no delay. Actually, Your Lordship. It is within the prescribed period of 60 days, Your Lordship.
Vacation from?
13/12/25 to 13/1/26. So that amounts to 32 days, Your Lordship. The bill was filed it was filed on it should be filed on 27/12/25. It should have been filed on 27/12/25, Your Lordship.
The next day it can be disposed of. Notice not issued.
We attention of notice. But are you serve notice to the other side?
Your Lordship, I'm appearing on behalf of the respondent.
Okay.
Your Lordship, ED, I'm the special public prosecutor. Your Lordship, we have not received any copy so far, Your Lordship.
You have not received any copy?
Yes, Your Lordship.
Notice was not issued. Today it's listing for the first time, Your Lordship.
Okay. Okay. Heard Miss Esther, learned counsel for the applicant, and also heard Mr. Your good name, please?
YP Gupta, SPP ED, Your Lordship. YP Gupta, Your Lordship.
YP Gupta for respondent opposite party number?
All responded, Your Lordship, Enforcement Directorate.
For all the respondents. Stroke opposite party. This application under section 42, under proviso to section 42 of the Prevention of Money Laundering Act 2002 is preferred by the applicant for condonation of delay of 26 days in filing the accompanying criminal appeal against the final order dated 29/10/2025 passed by the learned appellate tribunal Shefima, New Delhi, in PFA, the FPN SPMLA-5279 stroke ZWAs stroke 2022. Mr. Gupta, learned counsel appearing for the opposite party, respondent opposite party submits that he has not been furnished with copy of this application. Ms. Esther submits that she will furnish a copy of the same. How?
3 days, Your Lordship.
Within 3 days.
Yes, Your Lordship. Should I send through speed post or personally, Your Lordship?
Yes, any. Mr. Gupta, how the copy can be served upon you?
Your Lordship, personally also it can be served, Your Lordship.
Personally?
Yes, Your Lordship.
Okay. Ms. Esther submits that she will furnish a copy of the application to the learned counsel for the opposite party, respondent opposite party, within a period of 3 days from today. 3 days from today. Accordingly, it is provided that a recess shall list the matter after 3 weeks. No, sorry, after. Mr. Gupta, you will be filing your objection here?
Yes, Lordship, 4 weeks, Your Lordship, kindly 4 weeks may be given, Your Lordship.
4 weeks.
3 weeks, Your Lordship.
3 weeks. Mr. Gupta, 3 weeks?
Yeah, Your Lordship, since I have to send back the copy to Guwahati and thereafter it will go to the Calcutta, so it takes some time, Your Lordship. So kindly 4 weeks.
Okay, 4 weeks. In the meantime, Mr. Gupta shall file his objection, if so advised. If so advised, as all the respondents entered appearance. No, as Mr. Gupta entered appearance for all the respondents, no formal notice is required to be issued. It's after 4 weeks.
Oblige, Your Lordship.
For orders, item number 34.
Similar order can be passed, Your Lordship.
Okay.
Your Lordship.
Okay. Mr. Gupta, similar is appearing here, no?
But it's the same response from someone.
Same method.
Yes, Your Lordship, same respondents.
Same respondents. Okay.
Arising out of the same order.
Okay.
For orders, item number 37.
May I please, Your Lordships?
Yes, sir.
Lordships, I filed the writ appeal yesterday along with the IA. So I may be allowed to take steps for
This IA is for what purpose?
IA is for coordination.
Delay. How many days?
15 days, Lordship.
15 days.
15 days.
Okay. Heard, Mr.
Sentinel.
Learned counsel for the applicant. This interlocutory application under Section 5 of the Limitation Act is preferred by the applicant, struck appellant. How many days?
15 days. 15 days.
Where you have mentioned it?
I have mentioned it in paragraph 3 of the IA.
But in the cost title, you have not mentioned that it is for condonation of delay of 15 days. You have mentioned it as delay, if any. Page number 3?
Paragraph 3.
Page number 3 of your application.
He has to amend it. Make him amend his cost title. It should be clear here.
Yeah.
Make him amend.
You have not mentioned it in the cost title. Okay. What is the last word I have spoken? Pardon? By the applicant? For condonation of delay of 15 days in preferring the connected appeal, writ appeal against the judgment and order dated 12/12/2025 passed in WPC number 1 of 2025. The learned counsel for the applicant submits that there is delay of 15 days in preferring the connected writ appeal, and the same has been mentioned in paragraph number 3 of the application. Let notice be issued to the respondents to opposite party. Returnable in
Respondent number 5, Lordship. 1, 2, 3, and 4 have registered.
Who are appearing for them?
State.
No, they are not appearing.
I said yesterday, Lordship.
You take place, Steve. Upon all the respondents by registered post, no, by speed post and also by usual process, we can have it from today. List the matter after 4 weeks. Over.